Sometimes people will do estate planning by setting up joint accounts with, say, an adult child, or even register their home or their real estate jointly with an adult child. And people sometimes assume that when the original owner dies, then the other person, say an adult child, will receive those assets by something called a right of survivorship. But this is incorrect. It sometimes happens that they do, but it will depend upon the intent of the original owner of those assets. So others, for example, other adult children or other people who may have an interest in the estate of the deceased person, can challenge that joint ownership and the right of survivorship if they can show that the deceased person actually intended that the joint assets or the joint property be set up for either estate planning purposes or convenience to pay bills, but they did not intend that the other person, such as the adult child, actually receive those assets by right of survivorship. So I actually do a lot of these types of cases in court, challenging joint bank accounts and joint tenancies, and have succeeded a number of times in showing that, in fact, these assets do not go to the other person by right of survivorship, but are actually held in trust by that person for the estate. So then they actually go back into the estate and they can be distributed according to a will or according to the law of intestacy.